filed a notice of tender payment. I'm challenging the jurisdiction.
Actually, that's not correct. The file indicates that you submitted an affidavit of poverty.
On the order, it did not specify how to pay.
It was your obligation. Mr. Freehoff, please mute
ma'am,
Ms.
I need
Ballard
to
if
finish
she's gonna
what I
continue to
have to
speak over me.
say. You cannot make a
Obviously, you
ruling
disagree
over
with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make
did
a
not hear
ruling
you.
over something you can't know. You saying you don't know is an unacceptable response.
Before we go any further, let me set the stage for what you're about to witness, because this isn't just a rent dispute, this is a full-blown collision between reality and sovereign citizen fantasy land. Today's case centers around Miss Ballard, a woman who believes she's cracked some secret legal code that lets her live on property without paying rent, without contracts, and apparently without consequences. She walks into court armed with fake financial instruments, made-up legal language, and the absolute confidence of someone who learned law from internet forums instead of law school. Now here's what makes this entertaining and dangerous at the same time. Sovereign citizens don't argue facts, they argue vibes. They think words like tender payment, priority interest, and natural person magically override real laws. But courts run on evidence, receipts, contracts, and actual money, not imaginary loopholes. So what you're about to see is a judge patiently trying to decode nonsense while Miss Ballard digs herself deeper with every sentence. And trust me, this gets good. Because when the judge finally realizes there is no payment, no contract defense, and no real documentation, the tone changes fast. You'll see confidence turn into contradiction, and legal theater turn into a full-on meltdown. So buckle up, because this courtroom clash is part comedy, part chaos, and 100% reality check.
Ms. Ballard, I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make any presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, y'all.
Okay.
Right here is where sovereign citizen logic starts falling apart in real time. Miss Ballard keeps repeating, "There's no contract, so I'm not a tenant." And that sounds clever if you've never rented anything in your life, but legally, occupancy plus payment obligation equals tenancy, whether you like the label or not. You don't get to live on someone's property, use their utilities, and then declare yourself immune because you whispered the word sovereign. She's also throwing around phrases like priority interest and color of title, hoping the court gets lost in jargon. But the judge isn't confused, she's listening for one thing.
In my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60V, that, I mean, this is thrown out. I mean, it just, we don't have a contract. There's nothing to really argue here. So, I mean, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own.
Ownership is proven with deeds, leases, and payments. Not feelings. Not Google research. Not printed affidavits you typed at home. This is a common tactic. Overwhelm the court with complicated sounding nonsense and hope nobody calls your bluff. But the problem is, courts run on structure, not stories. And every sentence Miss Ballard adds just creates another hole the judge can drive a ruling through. And watch closely, because her confidence right now, it's about to collide with reality.
Okay.
I have priority interests and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that, and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment, and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because, again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action, and the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court, because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money.
Now the judge pivots, and this is the moment Miss Ballard starts to lose control of the narrative. The case stops being philosophical and becomes financial. Simple question: did you pay? Courts don't care what you believe you paid, they care what cleared, what posted, and what's documented. Miss Ballard says she paid all of it. That sounds strong, until the attorney says, no payment exists. And notice the contrast. One side speaks in documents, timestamps, and registry records. The other speaks in generalities, continuous basis, it's compliant, it's in there. That's sovereign citizen behavior in a nutshell, confidence without confirmation. She assumes the system magically validates her because she declared something. But the court isn't a wish-granting machine. It's a ledger.At this point the judge isn't even arguing, she's investigating. And when a judge has to ask for receipts, timelines, and transaction sources, it usually means someone is bluffing. And Miss Ballard? She's about to get exposed.
I apologize. I need to take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th. Respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue.
Here comes the moment of truth. The judge asks the most basic legal question imaginable. What exactly did you pay with? And Miss Ballard answers like someone explaining a dream. Basically a money order. Not an amount. Not a source. Not a receipt. Just vibes. And that's dangerous in court. Because money is traceable. Real payments leave footprints. Bank withdrawal. Issuer. Serial numbers. Registry logs. But sovereign citizens hate traceability because it exposes the fantasy. If she actually paid real money, the clerk would see it instantly.So when she can't say where it came from, how much it was, or who issued it, the judge already knows the answer. There was no valid payment.At this point, the case quietly shifts from dispute to credibility. And once a judge starts questioning credibility, the entire argument collapses. Because law isn't about how confident you sound, it's about what you can prove. Clip 4. After the break, notice how the judge tightens control. No more philosophical debate. No more theories. Just documentation. This is what professional judging looks like. Calm. Methodical. Focused on evidence instead of emotion. The judge even offers her an escape route. Bring receipts, bank logs, proof of purchase. That's generous. The court is basically saying, help me help you. But Miss Ballard doesn't bring proof, she brings more declarations. And declarations don't pay rent. This is also where sovereign citizen arguments usually implode. They assume the court must accept their paperwork because they filed something. But filing nonsense doesn't convert it into money. The registry isn't symbolic, it's financial.So now the pressure is on. Either Miss Ballard produces evidence, or the entire appeal collapses. And you can feel it. The courtroom energy shifts from debate to decision-making.
Pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made.
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Well, actually,
so I have to feel bad.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I tendered a payment in the magistrate court.
Right. I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
according to law, I tendered the payment, and I don't know if there's some type of mix-up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able, they even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly. Yes, so let me just turn on my camera real quick. Okay, so
Yes, ma'am.
I filed a notice of tender payment into the courts, and
This part is important. Miss Ballard reveals the real trick, tender payment. And that's Sovereign Citizen Code for, I didn't pay real money but I pretended to. Tender payment isn't a magical loophole. It doesn't replace rent. It doesn't override registry requirements. It's basically a written declaration saying, I consider myself paid. Courts don't accept vibes as currency. Sovereign citizens love this move because it sounds official. But legally, it's meaningless unless real funds accompany it. You can't print monopoly money, stamp it, and expect your landlord to applaud. What she's actually doing is confusing procedure with payment. Filing a notice doesn't transfer cash. It just transfers paper. And paper without money equals eviction paperwork.At this point, the judge already understands what's happening. Miss Ballard isn't broke, she's playing pretend finance. And courts don't play pretend.
It was filed in the magistrate court on December the 12th.
yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is, that money would be any, like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. Ms. Ballard has to comply with the order of the court before filing this appeal.
And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
what species?
Excuse me, Ms. Ballard, I'm speaking, and in a moment I'll let you respond.